All rise. Court is now in session with the Honorable George Young presiding.
Okay, good evening, everyone. Court is now in session. Just before we get started, I just want to preface this. I do have hiccups, so at some point you may hear some strange noises, and I assure you that I'm okay. I've just there you go. I just unfortunately developed some hiccups at the worst possible time. My name is Justice Alfie Young. I'm going to be presiding over this case 2024 CM222 State versus Bright-Starr. So just some ground rules I want to go over. Everyone needs to remain polite and courteous for the duration amongst each other and with members of the public and members of the gallery. And members of the gallery are expected to keep any noise to a minimum and not disrupt these proceedings in any way. I do also want to ask that if you're wearing any hats, masks, or glasses that are not for medical reasons or you don't have an exemption, please remove them now. I have a zero tolerance policy for anyone seen to be or perceived to be attempting to interfere with these proceedings or attempting to cause disruption. And anyone found to be in violation of the rules of my court today may find themselves charged without trial with contempt of court and obstruction of justice. I do need to add this, as has been the case in the past. There'll be no smoking, vaping, sniffing, snorting, or ingesting anything else that's not naturally found in the air in this courtroom. I also ask that unless you are acting in a security capacity, please do be seated for the duration of the trial. I just want to point out I've got the bailiff to my front here. They're going to be responsible for the security of this proceeding, as well as various other law enforcement officers around this courtroom. All right, can the state now please rise and state their names for the record?
Night.
State Attorney Jessica Ashbrook.
And your co-counsel?
Did you not hear him, Your Honor?
Prosecutor Vance Knight, Your Honor.
Did you hear him that time, Your Honor? Or
Yeah,
there?
we got
Okay.
that. It was you that I didn't hear. Sorry.
Me?
And the defense, can you please rise, state your name for the record, and defendant, if you would do so afterwards, please.
Public Defender's Office.
Montana Moss, Senior Public Defender.
Senior Public Defender. Bright-Starr.
All right, thank you very much. All right, does anyone have anything that they need to present to the court before we start going through to witnesses? Opening statements. Has everyone got an opening statement that they'd like to have?
Prior to proceeding, I just want to make sure that Yukigumi Holgard Marino was released from our subpoena. I believe we requested that on docket line number 55, if my memory serves me.
Oh yeah, my apologies. I didn't mean to respond. To respond to that. Now that we've got the affidavit, I'm more than happy to release the subpoena.
Your Honor, we also have one motion to make.
Okay, State, would you like to go ahead with your opening statement?
I don't know if you heard me, Your Honor. I do have one motion for the state to make, if you don't mind. Your Honor.
Your Honor, I'm not sure if you heard her.
No, I didn't hear anything up front here.
Also did not.
I'm trying to yell right now. If you can hear me, by chance.
I can.
Okay,
The record
wonderful.
can as well.
Noted. This is going to be fun, I think. We have a motion to make as a state, if you do not mind, Your Honor.
Go ahead.
The state wishes to have clarification. Are we all right to release Associate Justice Doc Hillard as he was present for the deposition the other day, due to the fact that we seem redundant as the defense was also present for his questioning?
Oh, no, defense objects to that.
On what grounds?
The whole motion for his deposition to begin with was to clarify things in his statement, and then obviously to lessen the burden at trial, not to completely eliminate questioning at trial. I don't believe this was ever brought forward before just now.
Yeah, I would agree. I'm going to overrule the objection, and we'll maintain the subpoena.
That's all right. We just wanted clarification as the other two were released and wanted to make sure before we continued.
No worries.
We are ready with opening statements if the defense is.
Defense is ready.
And prosecution, you may go ahead.
I'm not going to move out of fear because if I move, my voice might disappear. Respectfully. On June 30th, 2024, Chief Justice Killian Clarkson and Associate Justice Doc Hillard were on their way to post a welcome card to Governor Bright-Starr's house. They wanted to send their kind wishes and congratulate Miss Bright-Starr on her new adventure as a homeowner. Unfortunately, things then took a drastic turn, and Chief Justice Clarkson and Associate Justice Hillard found themselves in a situation they did not expect to be in. Miss Bright-Starr, as shown in her own testimony, and furthermore supported by ample evidence to the courts today, pulled out her firearm and threatened Chief Justice Clarkson and Associate Justice Hillard, demanding answers as to what they were doing on a public road. Then, when Associate Justice Hillard attempted to leave to preserve him and Chief Justice Clarkson's life, Miss Bright-Starr, with a gun still pointed at them, demanded for them to stay where they are and answer her questions, fearing if they did not do what she said, they would be then shot. Associate Justice Hillard and Chief Justice Clarkson felt they had no choice but to obey Miss Bright-Starr's illegal orders. Eventually, when Miss Bright-Starr lowered her firearm, Associate Justice Hillard and Chief Justice Clarkson fled to safety, but not before they heard Miss Bright-Starr shout, "Don't come back to my house or you will be shot." I present to you three definitions today. Assault with a deadly weapon. The threat of force against another individual or a group of individuals that involves the use of a deadly weapon without legal justification or an excuse. A deadly weapon, defined as a tool that can be easily and readily replicate death, must be presented even though it is not actively applied or fired during the commission of the crime, for this charge to be then applied. The deadly weapon must be shown or displayed as a threat of force or otherwise used to force others into doing the suspect's will against the individual's own wishes. As stated, Miss Bright-Starr used her gun against Doc Hillard, a well-seated justice in our legal system, to keep him there to continue questioning him. False imprisonment. The restriction of another person's movement within any area without justification or lawful detainment. Miss Bright-Starr knowingly restricted both justices from moving while having no legal authority to do so. And finally, uttering threats. Knowingly uttering, conveying, or causing a person to receive a threat of death, bodily harm, and or destruction of personal property. Ms. Bright-Starr then threatened to shoot both justices if they approached further, to which she admitted her own statements given to law enforcement on arrival. With the testimonies and evidence provided by the state today, we ask that Ms. Bright-Starr is held to the same standard as every other individual in the state of San Andreas and is found guilty of these charges placed upon her. Thank you.
Thank you very much. Defense, are you ready to proceed with your opening statement?
Yes, Your Honor.
All right, you may go ahead. Sorry, you may go ahead.
I missed the podium. Your Honor, people of the court, this case may very well be the highest profile case that the state has seen. The sitting governor is standing trial here today, and in the eyes of many in this courtroom, this trial began on July 3rd, on the day of the arrest. Since then, our governor has been tried, convicted, and sentenced many times over by the press, by legislative candidates, and by the public itself. This trial did not begin on July 3rd. This trial begins today. This trial begins right now. Our sitting governor is innocent until proven guilty, beyond a reasonable doubt, in this courtroom and in this hearing today. The state will call police witnesses that were not present for the events in question. The state will call the alleged victims to the stand, who have misrepresented their own actions since the day of the incident. As the state brought up in their opening argument, they were apparently there to give a welcome card to someone who has lived in a home for over a year. The state will call expert witnesses, one of which has no role in the application or justification of the legislation she wrote over 2 years ago. Today, the defense will show that these central witnesses in this case have inherent flaws in their statements and misrepresent what has happened here. We will show that the actions taken by the governor at her home are legally justified. We will show that Governor Ella Bright-Starr should be found not guilty here today. Thank you.
Thank you. All right, prosecution, you may present your first piece of evidence or call your first witness.
Your Honor, we would like to call Chief Justice Killian Clarkson to the stand, please.
Chief Justice Clarkson, if you wouldn't mind approaching the bailiff, please.
Go get him, champ. Oath. Can you hear me?
All right. Yes.
Okay,
Do you swear to tell the truth, the whole truth, and nothing but the truth? So help you God.
I do.
All right. May I have a seat?
Permission to approach the witness, Your Honor. Permission to approach the witness, Your Honor. Can't tell if you can hear me or not.
Your Honor, can you hear her?
Your Honor, can we motion for a sidebar real quickly?
All right, everyone who can hear me at this time, we need to
Excuse me a
reduce head
second.
count in the room. Lovely officers here are gonna come escort people out by random,
I'll
so
ask
we
him
can
just a
get
second, okay?
to head count, so the judge can hear.
No, I understand. Do you still want your sidebar, or would you like me to forward your other question? All right, now it's fine. I'm gonna go ask him if it's okay if you approach the witness while this is clearing out. Okay.
Are we still doing the sidebar once people get cleared out?
No, I've already spoken to the bailiff on the reason of the sidebar. It
You may
was
approach the
basically
witness, though.
what is happening right now. That's all I was going to ask.
Okay, yeah, that's fine.
All right, anyone in the back, if you are not a government employee here for the court case or a legislator or press, could you please exit the courthouse for me?
Oh my god.
Stevens.
Yeah, Weasel knew they're streaming it, so you won't miss it.
Stevens,
All
you
of
might want to tell
us-
people
all
it's
of us to leave.
it's on Weasel if they want to watch it.
All of us?
That might help.
That's what I've got them
make it
telling
right
right now.
All right, no worries.
Yeah, hello, Oliver.
Keep fighting the good fight, man. I love you.
Amen. Yeah, that's about what I expected. All right, we should be meeting. Head down to. It should be going swimmingly.
How many communists have you purged, sir?
What happened? What are they
America number
asking?
one, Mr. Hall. America number one.
I love this country.
Goddamn right.
They're related. Who's asking?
See.
Okay, if she's walking out, I was gonna say related individuals, but if she's walking out, then I'll just say that she consensually left. All right. So what's our head count now?
I think it should be fine, right?
Well, we want them to be fully gone.
Oh yeah, no. Sorry, I mean like after everybody's gone.
Yeah, I'm thinking this might be healthy.
Absolutely, Miss Ashbrook, you may approach.
Thank you, Your Honor. Good evening. How are you?
I'm okay. How are you?
I'm gonna get back.
I'm okay. Thank you for asking. Could you please state your full name for the record?
Killian Clarkson.
Thank you. Could you state your current occupation or occupations if you have multiple?
Yes, I am the Chief Justice of the San Andreas Judiciary. I'm the Chief Executive Officer of Nexus Technologies, and I am a partner in Sidebar and Tobacco.
Can you state for the courts today how long you've been in the Chief Justice position?
I think 7 months, since November.
Okay. Can you retell the courts how long you've been a justice within the state of San Andreas?
A justice?
Correct.
Probably a year.
Okay. Thank you. Do you recall why you were here today?
Yeah.
Could you restate the events from the evening of June 30th, 2024 to your best recollection?
Yeah, so Doc and I were on our way to Rick's house. We heard he was renovating it, so we wanted to stop by and listen. Not listen, but take a look. We got there and he wasn't there, so we decided to just drive back to. I think we were going to Sidebar. I don't know, but we stopped by Ella's house at the time. To drop off a welcome to the neighborhood letter because we had found that she had moved, just recently purchased the house. Doc exited the car. We didn't want to pull in her driveway, so he pulled. It was pretty much in the middle of the street. He exited the car, went up to the mailbox, went to open it, and as he did, Ella jumped down off of her roof with a gun, and then I think it was Emily, I don't know her new name, also jumped down. She aimed her gun at us. We attempted to leave the area. She told us no, told us to come into her parking lot or driveway. I didn't say a word. I didn't know what to do. I was scared, so I stayed quiet pretty much the entire time, while she aimed her gun at both Doc and I. Wouldn't let us leave. Continued rambling off questions like, why are we there? How did we find out that she lived there? And so on. Eventually, she put her firearm down, at which point Doc sped off, where she said if we ever came back, she would shoot us. And we went to VPD to report the crime.
Okay. From the events that night, were you the driver or the passenger?
Passenger.
Do you recall what you and Justice Hilliard were wearing that night?
Do I recall what I was wearing? No, I don't.
Okay. Do you recall if it was day or nighttime during these events?
It was nighttime.
At any point, did you witness the defendant's mailbox be vandalized?
I didn't know. I was, like I said, I was in the car the whole time, so I didn't go up to the mailbox.
Do you recall what the firearm looked like?
Yeah, it was like a, I don't know, kind of, it was a pistol, but it was red, white, and blue.
To reiterate, did you feel threatened by anything the defendant said to you?
Objection leading.
I'm asking him to reiterate.
Okay, then asked and answered then.
That's the same. Just move on, please.
Yep. Do you recall the police officers that spoke to you at VPD?
Yeah, it was Zach Sanchez, Detective Zach Sanchez. And then I think I also spoke with Marshall Wheatkins very briefly.
Okay. Were you clocked in at the time of these events?
Yeah.
Are you aware if the defendant was clocked in as the governor at the time of these events?
I'm not
Objection
sure.
assumes facts, not in evidence.
He would be one of the only few witnesses able to recall if he had noticed her being around on duty that day, Your Honor.
Yeah, overall you may answer.
I don't remember if she was on duty at the time of the incident, but I know she was on duty during the day at some point.
Do you recall submitting an interview with Detective Sanchez, Jackson, and Oliver Hall?
Yes.
Do you have a good or positive working relationship with the defendant?
No.
Have you ever been treated with hostility by the defendant before?
Objection leading.
I wasn't even done with my question, Your Honor.
You may finish the question and then we'll review the objection.
Thank you. Have you ever been treated with hostility by the defendant before, either verbally or physically, that you can remember?
Can I answer?
I'm going to overrule the objection. It's just asking the witness here on the stand just about some history and painting a picture. So I will allow you to answer that.
Yes, I have.
Okay. Circling back to the interview, you were asked if you felt this could have been a way to assassinate you, and you stated it could have been, to quote exactly as you said, "I don't know, Mamie. Some time has passed now. You've been able to think about the situation. We would like to ask you the same question here on the stand. Do you feel the defendant tried to use you in this situation as an excuse to assassinate you?"
Objection leading.
He's the only one who can testify to his own statements that he has said from his own mouth, Your Honor.
I have a further response if you'd like.
Go ahead.
Regardless of him being the only one to answer that, the question's form is what is leading, not the contents, if you will.
Ms. Ashbrook, would you like to rephrase?
No, at this time we can withdraw our question.
Okay.
No further questions at this time.
Thank you. Defense, would you like the opportunity to cross?
Of course, Your Honor. Hey, Killian.
Hello.
I guess I'll try to start at the start. How did you and Doc learn the location of the governor's house?
A friend of Doc's told Doc.
Okay. And how did you determine it was recently purchased?
I believe that's what was told to Doc.
Okay. Whose idea was it to go there?
I think it was just spur of the moment. So, I mean, maybe mutual.
Okay. Were you kind of together with Doc for most of that day?
Yeah.
Okay, so did you notice the broken mailbox earlier in that day?
Objection, Your Honor, asked and answered in the prosecution's lines of questioning.
Yes, sustained.
I did have a rebuttal if you're willing to entertain it, Your Honor.
Just continue. Just carry on. Next question.
Give me 1 second. Are you aware of any threats to the governor's life?
Objection, Your Honor, facts not in evidence.
My rebuttal would be it's the same line of I'm asking if he's aware. I'm not referencing any facts that are not in evidence.
Then, Your Honor, another objection add on to that lacks foundation, was not not built in the prosecution's line of questioning.
I will sustain the lack of foundation. So if you'd like to ask any more questions relating to that, you may.
Okay. Did either of you inform the governor that you were going to their house?
Objection, Your Honor, lacks foundation as well.
I assume you have a rebuttal?
The foundation is that this whole thing is built on them going to the governor's house. I don't see how there is a lack of foundation here.
Your Honor, in the defendant's own answers, he stated that they had driven. There was no form of him stating that there was any contact, so therefore lacks foundation. Nothing was ever mentioned on a piece of contact between them or the governor.
I will overrule the objection, and Chief Justice, you may answer.
Can you repeat the question?
Yeah, did either you or Doc inform the governor that you were going to their house?
No.
Okay. To the best of your knowledge, would the governor know that you've learned the location of her house?
Objection, Your Honor. One moment. There's a little demon that decided to walk in at the same time. Objection, Your Honor, calls for speculation.
Okay. Judging by no rebuttal, I will sustain the objection.
All right. 1 moment. Let's talk about the police interview on the 3rd.
Okay.
Did you and Doc and Oliver Hall arrive to that together?
Objection, Your Honor, asked and answered in the prosecution's line of questioning.
My rebuttals, I don't think that question was asked.
Yes, it was, Your Honor. I have notes of it. If we could have the transcript be reviewed on that.
Yeah, if you don't mind.
Do not mind at all.
You'll have to give a moment for the transcript.
No problem.
Let the record show the state asked if the witness remembers submitting an interview with Detective Jackson, Detective Sanchez, and Oliver Hall present during the interview.
Thank you. Thank you very much. Yeah, that's not the same question, so I will overrule the objection in this case. If you can repeat the question for the witness, please.
Yeah, of course. For your interview on July 3rd, did you, Doc Hilliard, and Oliver Hall arrive together?
No.
Okay, in that case, did you all drive separately? How did you guys get there?
I drove. Oliver Hall was already there for his cell rep.
Okay. Was Oliver Hall already representing you prior to getting there?
I called him on the way.
Okay. Apologies. at around 6 minutes, you say, I believe, sorry, around 6 minutes of that interview, you say, quote, "It's no discrepancy, no public secret that I can't stand the governor. It's very public knowledge that she doesn't like me and I don't like her." Was that your opinion of the governor prior to these events?
Yeah.
Objection, Your Honor. Irrelevant to the case at hand.
My rebuttal is that the relationship between the Killian, Doc, and the governor, I think, is tantamount for why they were at the governor's house to begin with, which is very relevant to the case.
Your Honor, it has nothing to do why she pulled a gun on him.
Any further rebuttal?
My further rebuttal is that the state already explored the relationship between Killian and the governor, so if it is not relevant, I don't see the point of the earlier questions.
A final rebuttal from the state. We did ask if there was any previous threats against the governor, to which the individual on the stand has already answered. So at this point, it's becoming redundant.
Yeah, I see both viewpoints here. I think ultimately it falls down to that it's being asked in a different way, and it's directly referring back to evidence that's been submitted to the record. So we'll allow this question, overrule the objection in this case.
Do you need me to repeat, Killian?
Yeah, but I thought I already answered it. But yeah, if you can.
Actually, yeah, it was already answered. My fault. So, forgive me if I misstate your earlier answer. So the plan was for you and Doc to show up in the middle of the night, unannounced to the house of a person that you do not like. Is that correct?
Objection, Your Honor. Badgering the witness.
Sustained.
All right. Let me ask it a different way. Why did you want to go to the house of someone you do not like?
Objection, Your Honor. Badgering still.
Can you rephrase the question?
I could. I'm using a direct quote from him, Your Honor. I don't think I'm doing anything provocative here.
I think the choice of word is quite provocative. You may be using a direct quote, but I don't think it's necessary to be in this courtroom in the way that you're presenting it right now. So if you would like to rephrase, that would be great.
Okay. Is there a reason why you and Doc went to the home of someone you have a negative relationship with?
Yeah.
And what was that reason?
I'm sick of the toxic working relationship that my office has had with the governor. So in an attempt to extend a leap of faith, I thought being nice, because I'm sure somehow, some way, it was going to get to her that Doc and I were the ones that put the card in there, trying to be the bigger person and taking the first step at being, adults, and take that first step to mend a completely destroyed and broken working relationship.
Okay. How was the governor going to know that you guys left the card?
I'm sure it would have come up in conversation in San Andreas.
Is there any particular reason why you chose not to inform the governor you guys were going to her house?
Objection, Your Honor. Starting to badger and also becoming irrelevant. It's still not directly against the charges that we're currently presenting to their client today.
I'm also pretty sure that this is just a rephrased question of a question that's already been asked, so I will sustain the objection in this case.
Okay, give me one moment to confer. Nothing further from the defense, Your Honor.
Thank you very much. Sorry, excuse me. State, would you like the opportunity to redirect?
No, Your Honor. Are we all right to release the witness from his subpoena?
I see no reason to. Thank you very much, Chief Justice. Your time is very much appreciated. You are hereby released of your subpoena. Thank you.
Thank you.
Come here, buddy. You did so good. I'm proud of you. Come here, buddy. It's okay. Just let it out. I can't believe what they did to you. You didn't do anything.
Your Honor, the state would like to call Detective Zach Sanchez to the stand, please.
I'm proud of you, buddy. I know it was hard for you.
Detective Sanchez, if you'd like to go and approach my bailiff, please, to get sworn in.
Oh my god.
I'm good.
Are you okay? You need a hook?
I can. Can you hear me?
Oh, here you go.
Oh, it's fine.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you
It's
may take
okay.
a seat or stand behind the
You'll
bench.
be okay. Oh no.
Goes
Do
to
you
the
need
gallery,
some
please keep
liquor?
it down, please.
So sorry.
Your Honor,
State
may I
you may
approach?
proceed.
May I approach?
You may.
Good evening. How are you?
I'm doing well.
Beautiful. Can you please state your name and your full name for the record? Oh, I can speak.
Yeah, Zach Sanchez.
Could you tell us your current occupation?
Yeah, I'm a detective within the Major Crimes Division.
Can you tell us how long you've been a detective with the Major Crimes Division?
I've been a detective for the last couple months. I don't know. I think it's been closer to 2.5 to 3 months.
And have you been an officer prior to that?
April.
Can you tell me how long?
I've been in law enforcement for a little over, almost close to 2 years. No, yeah, almost close.
Can you tell the courts today your involvement from the evening of June 30th, 2024?
I'm sorry, can you repeat that question?
Yep. Can you tell the courts of your involvement from the evening of June 30th, 2024?
Yes. So on the evening of June 30th, 2024, I received originally I received a call from, I think her name was Amy, I don't know the new name now. But they were calling for vandalism at the governor's house. I went out to the governor's house to collect the mailbox, take photographs of it. They advised that the mailbox had been vandalized, looked like it had been kicked over. I documented it, started an IR for that, or an incident report, and then cleared that scene. A couple hours later after that, I received a phone call from Governor Ella Bright-Starr advising that two members who she advised were Chief Justice Killian Clarkson and Associate Justice Doc Hilliard had arrived in front of her property and were messing with her mailbox. At that time, she advised that she had hopped down, ran up to them with gun in hand, aimed at them, and were trying to question them. She also told me that she had advised them that they were not good to go and that she wanted them to stay so that way she can get more information out of them on why they were at her house or even how they found out about her house. Throughout that conversation, she advised me that she wanted me to trespass them from her property. And if they were to return, that I would have 2 dead judges on her property.
Okay. Could you review Exhibit A for me, please?
Yes, please give me 1 second.
Yep.
I'd like to object. No exhibits have been entered into evidence at this point.
Your Honor, to go past that objection, all exhibits have been recognized by the court prior to even us entering to the courtroom.
I will agree with Miss Ashbrook over there. All exhibits have been entered into the record. We're now just referring to them during the course of examining the witness. So it was Exhibit A is what you called?
Yes, Your Honor.
Okay, thank you.
Okay, I'm ready with Exhibit
Does this exhibit explain the 311 call that you responded to?
Yes, this was the 311 call that happened after my phone conversation with Governor Bright-Starr.
Okay. Can you now review Exhibit K for me, please?
Okay, I have exhibit.
Does this exhibit look familiar to you?
Yes, it does.
Can you tell the courts what this exhibit is, just out loud?
I'm sorry, if you can give me 1 second. I had the wrong exhibit open.
You are fine. Take your time, please.
Okay, I am ready, and I can explain what this exhibit is.
Please.
So Exhibit K is going to be the phone records for the call that was made between the governor and myself.
Okay. Do you recall gathering any statements from Miss Bright-Starr regarding that evening?
Yes, I did not gather the statement. The Marshal Wheat Kings and Lieutenant Lars went out to the property, met with the governor, and then the governor did email the statements over to all of us.
Okay, can you look at evidence F1 for me, please?
Yes, I can.
Let me know when you are ready.
Okay, I'm ready.
Can you describe F1 to the courts for me?
Yes, this is a statement that we received from Governor Bright-Starr.
And can you look at exhibit F2 for me, please?
Yes.
Can you tell the courts what this is as well?
This is the email that we received from Governor Bright-Starr with the statement inside.
Thank you. No more further questions, Your Honor.
Thank you, defense.
One moment, Sanchez. I just walked over here and shuffled my notes in the wrong order. In your initial testimony from the state, you stated you collected the mailbox from the property when you responded to it. Is that correct?
Objection, Your Honor. Already asked and answered. We would like it rephrased if the defense is trying to ask a specific question.
Sustained.
Okay. Yeah. In the depositions that are not marked with an exhibit letter, so apologies for that, of Ricky Lars and Mitch Wheat Kings, both attest that Ricky Lars collected the mailbox from the Bright-Starr property.
Objection, Your Honor. The question is lacking foundation from the prosecution's line of questioning.
I believe the foundation is that he stated he collected the mailbox.
Your Honor, this specific piece of evidence he's trying to recall was
I also
not established.
If I may, Your Honor, we just went over that evidence does not need to be established.
It still needs to be called in, though. If you're going to ask a question about a specific piece of evidence, then you will need to mention that you are referring to a specific exhibit.
I believe I was, Your Honor, referring to the depositions.
Yeah, that's fine. I'm just saying you just need to refer to it. So if it's Exhibit A, then you call it Exhibit A.
Okay. I guess a clarification question. The original objection was off of Foundation for asking about the mailbox when he stated in his testimony for the state's questions that he collected the mailbox. Did you rule on that portion of the objection, Your Honor?
No, I haven't. I will overrule the objection for that specific part of the question. So you can repeat that question if you'd like.
Okay. Apologies. According to the depositions of Ricky Lars and Mitch Wheatkings, they both affirmed that Ricky Lars collected the mailbox from the Bright-Starr residence. My question is, how can the mailbox be collected twice?
Your Honor, we're going to at least object to part of that question, the fact that he's calling upon the depositions of Mitchell Wheatkings and Ricky Lars on the fact of hearsay. He was not there for the depositions.
Sustained.
Okay, we can come back to all that. Well, I want to start with the statement of facts for this on the indictment, which is automatically entered in the evidence as procedures of court. Did you write the statement of facts?
Yes.
Okay. In the statement of facts, there is an exact quote of Clarkson and Hilliard advised that they had located the house from a conversation between court clerks in both parties. This is not mentioned in any further statements or interview. Where did this information come from?
That statement came from the conversation that we had inside of the Vinewood Police Station when we responded to a 311 call from Chief Justice Clarkson.
Okay, was there any other information discussed during that was not captured in the statement of facts?
Objection, Your Honor, irrelevant due to the charges that are currently being presented to the defendant. Everything has already been presented to the courts.
My rebuttal is that I'm asking if statements given on the time of the incident are wholesalely recorded so that we can properly form a defense.
I will overrule the objection in this case.
Do you need me to repeat the question?
Yes.
Okay. Were there any other statements in that conversation of VPD that were given that were not reflected in the statement of facts on the indictment?
The statement of facts is accurate to the best of my knowledge. Yes.
Oh, with all due respect, I don't think that was my question. Were there any other statements in that conversation that are not in the statement of facts?
Objection, Your Honor, asked and answered and badgering the witness at this point for an answer.
My rebuttal is that yeah, thank you.
No, there were no other statements.
Okay, so that entire conversation, all they did was advise you of how they had come to learn the location of the Bright-Starr residence, and that they were there to deliver a welcome to the neighborhood card, and yeah, that was it. Those are the only two statements you have from them in the statement of facts.
Objection, Your Honor, badgering at this point for answers. If it can be rephrased, we would be fine with it.
Yeah, I could rephrase. That was a bad one. I'll admit fault. If the conversation of VPD is fully reflected in the statement of facts, were there any statements given beyond the location, how they learned the location of the governor's mansion, and their purpose for being there?
Objection, Your Honor, compound question.
Yeah, if you'd like to split them up into separate questions.
I can actually move to a different portion, if you will. In your experience as a police officer, is it more difficult to identify a suspect at night?
Objection, Your Honor, relevancy.
According to prior testimony, this incident happened at night. He is a police officer, so would be sufficiently able to define whether it's more difficult to identify someone at night or in the day.
Then we ask for it to be rephrased as it's a little vague and open for the individual to answer.
Sorry, excuse me. I will sustain the objection on the grounds that it's rephrased and reduce the scope.
Yeah. Is it more difficult to identify somebody at night or during the day?
Objection, Your Honor, irrelevant. Didn't ask any form of question as regard to his experience whatsoever. What's the relevancy to this?
Fine, I will rephrase. In your experience as a police officer and as a detective, is it more difficult to identify potential suspects at night or during the day?
You answer the question.
It can be more difficult to identify someone at night.
Okay. I want to talk about the police interviews on July 3rd. Did you conduct those interviews with Detective Jackson?
Yes, I did.
And did you conduct interviews for both Doc Hilliard and Killian Clarkson?
Objection, Your Honor. We would like to know the relevancy to the charges that are currently being presented today.
I'm asking about the interviews for the primary witnesses that are whose statements are central to this case. I believe that is the direct relevance.
Understood, but we would like to know the objection, like if there's any further questions that will actually lead into what you are asking regarding this, essentially.
Can you repeat the question, please?
My question was, did you conduct the interviews of both Doc Hilliard and Killian Clarkson on that day?
I will allow the question and overrule the objection.
Yes, I did.
Did Oliver Hall represent both witnesses?
Objection, Your Honor, irrelevant.
Sustained.
That's fine. Is it standard to ask a lawyer for a witness if they would like anything added to a police interview? For the
Objection, Your Honor, irrelevant.
Sustained.
Okay. And just to clarify a question brought up from the state earlier, on Exhibit K1, you state that phone call was from Ella Bright-Starr, correct?
Objection, Your Honor. If it's restating, that's fine, but it's already been asked and answered.
I'm not looking for anything different. I'm just looking to just confirm that.
That's the definition of
the
asked.
objection. You can re-ask the question and clarify.
Yeah, just for clarification's sake, in Exhibit K1 from the state, do you believe this phone call was your phone call with Ella Bright-Starr on that night?
To the best of my knowledge, yeah, I believe that that was the phone records that were pulled for the call that happened between Ella. I don't know the number off the top of my head to confirm.
Okay. I would like to refer the courts to the private Exhibit K2, and for the sake of not revealing the name to the public, I would like to make it known that Ella Bright-Starr was not the recipient of that phone call.
So noted.
Are you aware of any threats to the life of Ella Bright-Starr?
Objection, Your Honor, irrelevant to the trial and matters at hand. Threats doesn't excuse the fact a gun being pointed at someone.
My rebuttal is that credible threats to someone's life might be a reason to point a gun and be a bit more on edge.
Your Honor, not when it's in a public area.
We're just testifying at this point, Your Honor.
I will overrule the objection and allow the question to be asked.
Perfect. Are you aware of any threats to the life of Ella Bright-Starr?
I am not personally aware of any threats. I also can't speak on any open cases.
Okay. So when you responded to the vandalized mailbox, that was kind of your first inclination of any crime that has happened to the governor.
Your objection, Your Honor. It's going to be hearsay at this point.
Sustained.
Okay. When you collected the mailbox, what forensics tests analysis did you do?
Objection, Your Honor. Hearsay, given the fact that's already included in the deposition. He was not the individual that collected the mailbox. That would have been Ricky Lars.
Sustained.
Your Honor, his earlier testimony was that he collected the mailbox. I believe that's reflected in the court record, and that was actually objected to earlier. And I was not allowed to bring up the depositions of Lars and Wheat Kings.
Your Honor, it's already been submitted by the courts and accepted the depositions. I don't know what to say because the individual, the defense, was also there for the depositions.
Right. I guess my Detective Sanchez here stated earlier in his questions from the state that he collected the mailbox when he responded hours before this incident with the justices.
Can we have court record be brought up and see if that is the case, please? And can we have a sidebar if it's going to continue going back and forth?
Sure. While we let the court record be updated, we'll double check that. Let's have a sidebar. Thank you everyone for waiting. Court Clerk Flash, would you just like to advise everyone for the record what the record showed?
All right. I will reiterate what I just said. For the record, Detective Zach Sanchez received a call approximately 2 hours earlier in the day from the incident that we were on trial for. The call was for vandalism. Detective Zach Sanchez went out. He, 1, documented the scene. 2, he made an incident report of the scene. 3, he cleared the scene. That he did not say or state or anyone asked if he had collected the mailbox.
Thank you
That
very
is all.
much. And you may proceed with your further questions.
All right. Yeah, I'd like to circle back to those interviews on the 3rd, if we will. Apologies for jumping around. Let's just a couple more questions. I'll be done. I promise. What was the purpose of those interviews on July 3rd?
Objection, Your Honor. Relevant.
I will overrule the objection and just ask. I'm happy to hear what the intent was.
The purpose of the interviews on July 3rd was just to get more clarification on the incident, get it down on the recording versus just like a written statement, especially after it had been a couple days since the incident. Maybe new information would have come to light or anything like that. So we just wanted to get it on recording and document.
Okay. Did you believe there's a inherent conflict given that the two witnesses are boss and subordinate?
Objection, Your Honor. Irrelevant.
I think it's very relevant on if the witnesses have any conflict or bias when giving a statement.
Your Honor, it's not to the subjects that were mattered on trial. He's asking more of a personal type of question to figure out what's going on.
I would also agree that we're bordering on speculation as well in relation to the relationship of two witnesses. So I will overrule the sustain the objection. If you can move on, please.
Okay. Is it standard in interviews that you conduct to allow the lawyer of a witness to add questions for the record?
Objection, Your Honor. Irrelevant to the matters at hand on trial. And is now just starting to badger the witness with questions.
I mean, I'm trying to forge a path here, Your Honor. You know.
I'm failing to see the relevance behind it. Would you like to lay a foundation question before re-asking the question?
No, Your Honor. Well, let me confer with counsel.
Okay.
Okay. Sorry about that. You were the primary officer that pushed these charges, correct?
Yes.
Given that there are conflicting statements, how did you determine which was more likely to be the factual outcome, what actually went down?
Objection, Your Honor. Calling for a conclusion.
Your Honor, there are conflicting statements. I'm asking how he came to the conclusion. Well, I guess I am calling for him to come to a conclusion, but he did so in the matter of the investigation. I'm asking how one was determined to be more valuable than the other.
Your Honor, we're still standing with our objection given what he just stated.
Yeah, I will sustain that. If you wish to rephrase the question, you may.
Sure. In the statement, let me pull up the exact exhibit. I believe it was J1, but I can give me one moment. Apologies. In Exhibit I from the state, the statement from Emily Lilgard Marino, now known as Yukigumi. The quote is that. Apologies. Jesus. One moment. Apologies. Okay. Exhibit F from the state. The governor's statement given to you, lawyers and Wheat Kings, states that the governor put her gun down once she identified Doc and Killian. Did that conflict with the other statements and interviews you collected?
Objection, Your Honor. Call for speculation. And also calls for a conclusion. He's asking for his opinion, not a fact.
Sustained, yeah. If you'd like to ask based on facts, about anything that could be considered calling for a conclusion, anything that may be speculative, speculatory, whatever the word is, I'm not sure which one's best to use there. But you're more than welcome to rephrase the question.
Okay. Were there conflicting statements from the parties involved?
Objection, Your Honor. Still very irrelevant, and we are now going in circles, trying to rephrase the same question over and over again.
I'm going to overrule the objection for this question, but I do hope that you're going somewhere with these questions.
I'm trying to, Your Honor. I can restate it just for the record. Were there conflicting statements given in this case from the witnesses involved?
To the best of my knowledge, during collecting the statements, they aligned, so I didn't see any conflicting statements.
Okay, perfect. One moment, I believe I have nothing further, but let me just double check. Nothing further, Your Honor.
Okay. State redirect.
One moment, Your Honor. No, Your Honor. We're good to release him from his subpoena.
Perfect, Detective Sanchez. Thank you very much for your time. You may go and take a seat back in the gallery, and you are released from your subpoena. Thank you for your time this evening.
Thank you.
Any further witnesses?
Yes, Your Honor. We would like to call Detective Nicholas Jackson to the stand, please.
Okay, Detective Jackson, if you'd like to approach the bailiff, please.
One moment, Your Honor, please. Can we take a 5-minute recess momentarily, Your Honor?
Absolutely.
Just trying to figure out where the witness is.
Okay, no problem. We'll reconvene at 20 minutes past the hour.
defense. Can you come here a second?
Yeah, come over here, guys.
Thank you. Thank you. Hello. Don't look at me. I'm hideous. What? When did I do that? I don't remember. No. Yeah. It's funny, I did so much and we still breached. Yeah. Oh, yeah, I do remember that. Yeah, it was Grove Street, wasn't it?
Oh, you're right. You're right. Sure did. Oh, would have been days. I sure do. Just once in the morning. What are they talking about again? They're talking about Jackson.
You're talking about Jackson.
Okay. Yeah, what's up? Mm-hmm.
Alright, thank you everyone for the time there. I know that's taken quite a while. Just for the record, we have released Detective Jackson of his subpoena, and he's not required to be here in this courtroom. So, Miss Ashbrook, your next witness, please.
Your Honor, actually, we would like to release a witness, and I'll explain why momentarily. Let me just get my notes. Exhibit N had been denied by yourself, Your Honor, and there was a witness called in direct correlation to that. If I'll give you a moment to review and look at it before I continue.
Let me just double check Exhibit N.
As you are double checking, it would be HR 112 that was denied.
Yeah, because that's case law, correct.
Correct. We would like to release Bex Lawson from her subpoena, as the only reason that she was brought on was as an expert witness for such. We don't believe that she should be obligated to be here if the evidence isn't even there.
The reason that I denied that as evidence, just so you're aware, and I'll explain that a little bit more now. A specific law doesn't need to be called in as evidence because it exists. If you still wish to call an expert witness on said piece of law as it relates to this case, then that is something that I'm amenable to. But ultimately, it's your decision as to whether you would like to or not. But the only reason I didn't enter it as evidence is because there's no need to enter it as evidence.
No, Your Honor, we would still continue with that.
All right, defense, any objections from you?
To be clear, the continue is just the motion to release.
Yeah, we just want to release her, move things along, kind of keep going.
Yeah, no objections.
All right, perfect. Thank you very much. Ms. Lawson, I appreciate your time and being here in the courtroom today. You are hereby released from your subpoena, so if you would like to leave, you may, but you are more than welcome to stay as well. Thank you. Anything further from the state?
No, Your Honor. We just want to make sure that all evidence otherwise that has not been denied is submitted, and then we are done.
Okay, perfect. There is one thing that I did want to go over in relation to the deposition of Doc Hilliard. There were some objections that were raised during the deposition. There was a question that was asked by, I believe it was Montana Moss. It was relating to, it says here, on Killian's interview on July 3rd, I believe you had an interview on the same day as well. About 6 minutes into that interview, he said it's no discrepancy and no public secret that I can't stand the governor. It's very public knowledge that she doesn't like me and I don't like her. Would you say that's a fair assessment of their relationship? Ms. Ashbrook, you raised an objection to that for speculation. And Montana Moss rebutted with Killian and Doc are very close. I'm sure they've spoken about their very personal feelings about the governor many times, etc., etc. To which Miss Ashbrook responded to that. He's asking him to base his judgments on someone else's statement. He didn't state himself whatsoever. I just want to go back over to that specific part, and I would agree that that is speculation. I will be sustaining the objection in that case, and that specific section of the deposition will be stricken from the record. Another objection was raised. A statement from Montana Moss states, according to a different statement on scene, Yukigumi Lilligard Marino states that you told her that the mailbox is already broken for a while. Is that correct? To which Doc responded with yes. And Miss Ashbrook, you responded with an objection for speculation. Montana Moss states, I'm asking if he said something. To which I agree. He's asking a specific statement as to what he's aware of, so I will be overruling that objection and allowing that section in. And there was one final part, approximately 23 minutes and 19 seconds into the deposition, to which Montana Moss states, just to be clear, you showed up in the middle of the night unannounced to someone who has threats to their life, and we're going to announce that you put something in their mailbox at a later time. To which Mr. Ashbrook objected for badgering. The response was, I'm simply combining the answers of previous questions to get a truthful picture of the motive from being there that night. I would agree that at this point we've asked the question many times and it is badgering. However, in this case, I do believe that the question is of material importance to the case, so I will be overruling that objection. So the section between 23 minutes and 19 seconds and 24 minutes and 29 seconds will be kept on the record. Is everybody happy with that? Based on what I've just said there, I know it's quite a lot of information I just threw out all at once.
Yes, Your Honor. My brain might need a moment to reboot, though.
Mine too.
Yeah, no issues, Your Honor.
Perfect. I also went through the other two depositions. I've had those transcribed as well. There were no other objections that I could see in those, so there's nothing else that we need to add in relation to those. Okay, with that state, is there anything further that you would like to add?
No, Your Honor.
And just to confirm, are you resting at this time?
Yes, Your Honor, we are resting.
Perfect. Would anybody like a break before we change sides?
If you wouldn't mind, it's been a bit of back and forth. I just need to grab some water.
That's fine. Okay, let's meet back at 42 minutes. Does that work for everyone?
Yeah, that works.
Perfect. All right, we will reconvene at minute 42. Thank you.
How what? Oliver? Okay. Mr. Hall,
Yes,
the
that's
judge
me.
Would, the judge would like to know how big his lip really is.
His lip.
Your Honor.
Oh, it was? And 4. Yes, sir. Did you hear that, sir? You want me to go ahead and call court? All rise, court is back in session.
All right, perfect. Defense, would you like to call your first piece of evidence or your first witness?
Yes, the defense would like to submit their Exhibit A, the sales contract of the 2888 Hillcrest Avenue in which the governor lives. The defense would like to also submit their Exhibit C, which is the sworn affidavit of Yukigumi Marino.
So Exhibit A and Exhibit C to confirm.
Correct.
Okay, let me grab those. Sorry, just having a little bit of trouble trying to find Exhibit A. Oh, there we go. I've got them. Perfect.
Okay. Your Honor, we don't have any witnesses we would like to call to the stand, so we will rest.
Okay. All right. Do we have any closing statements?
Given that, because we are expecting to go back and forth, we request 3 minutes, Your Honor.
3 minutes is granted. I'm not going to go back into the chambers. Just let me know once you're ready.
That's fine.
Your Honor, request being able to proceed.
State, are you ready to go ahead with your closing statements?
We're ready, Your Honor.
Okay, State, you may go ahead with your closing statement.
Thank you, Your Honor. Your Honor, everyone here today and those watching at home. We have a goal and obligation on all sides when we enter a court case. We are here to present the facts, the evidence, and to prove beyond a shadow of a doubt for you to understand the events that happened on June 30th, 24. But all of that has been presented to courts is the fact that the state has proven the burden of proof. Allow us to expand on that for a moment. Referencing the many condemning pieces of evidence, this case had nothing but solid points, all of which led to the fact that Mrs. Bright-Starr is guilty on all counts. If we refer to Exhibit 01, this piece of evidence clearly shows us that the property lines on Mrs. Bright-Starr's property. From this, we can reference Exhibit D, which shows that the mailbox at the victim's approach was clearly on the edge of the property, a line alluding to the fact that Mrs. Bright-Starr drew her weapon on the victims whilst they were on a public road. I again circle back to then Exhibit F1, where the governor herself admits to the committing of the crimes that the state has brought up against her today. I want to recircle to the state's opening statement and reiterate for everyone to hear the definitions of each charge and how many times they have been pressed against Mrs. Bright-Starr. 1 times assault with a deadly weapon. The threat of force against another individual or a group of individuals that involves the use of deadly weapon without legal justification or an excuse. A deadly weapon, defined as a tool that can be easily and readily replicated death, must present true. It is not even actively applied or fired on during the commission of a crime. For this charge to be applied, the deadly weapon must be then shown or displayed as a threat of force or otherwise used to force others into doing the suspect's will against the individual's own wishes. We all know that Mrs. Bright-Starr used her gun against Doc Hilliard as a well-seated justice in our legal system to keep him there at all cost, and also by Chief Justice Clarkson, which can be heard and testified against too today in court, and also stated by Miss Bright-Starr herself in Exhibit O. 2 times false imprisonment, the restriction of another person's movement within any area without justification or lawful payment. Miss Bright-Starr knowingly restricted both judges from moving while having no legal authority to do so. She is not an officer of the law. Again, it can be referred back to Chief Justice Clarkson and by Associate Justice Hilliard in their statements directly, and also stated by Miss Bright-Starr and herself in Exhibit O. 2 times uttering threats. Miss Bright-Starr threatened to shoot both justices if they approached her, to which it is defined as knowingly uttering, conveying, or causing a person to receive a threat of death or bodily harm and or destruction of personal property. This can be heard by Chief Justice Clarkson and by Associate Justice Hilliard, both who were scared for their lives or for any further damage to be happening as they drove away, and also stated by Exhibit O. There was no defense given, Your Honor. The only defense was given was the evidence into submission at the end, to which they submitted Exhibit A, the Bright-Starr resident's purchase information. There is no direct denying following the crimes had been committed. All the evidence does is show nothing. Paperweights. Because if you look at Exhibit O and D carefully, you can see the mailbox is indeed off the property line. No defense can argue with the facts that are presented by the lawmen and women of the state of San Andreas. Your Honor, there is no plausible reason to support these claims of what she did to confess within the law. It was well outside of it. We have a duty and obligation to uphold everything into the same standard. With the undeniable and unshadowed doubt of given today, we ask that Miss Ella Bright-Starr be found guilty on all charges. Thank you.
Thank you, Miss Ashbrook. Defense, are you ready to proceed?
Sorry, I was whispering. Of course, Your Honor. 1 moment. I'll approach the podium. Your Honor, people of the court, to begin, I want to recognize the faults of the primary witnesses, which this case is centered around. The state wants to paint them as honorable as faultless, when the simple fact is that both of these men in this case can only be seen as scheming, conniving, and as a bit petty. Doc Hilliard and Killian Clarkson say they want to deliver a new home letter to the governor to serve as a welcome to the neighborhood. The governor quite simply has lived in that home for a year. And Doc Hilliard, the driver of the car, does not live anywhere near the governor, as stated in his deposition, so would live nowhere near her neighborhood as a result. Doc Hilliard confirmed in his deposition that he drove to the governor's place in the middle of the night, unannounced. He did this with Killian Clarkson, who does not like the governor, and said as much unprompted in a police interview. To paint them as unassuming and innocent and unbiased would completely misrepresent what has truly happened in this case and would completely misrepresent how they felt about the governor even before these events happened. Today, the primary officer involved states that no witness statements conflict, despite there being clear differences in when parties state the gun was lowered in this incident and how the judiciary came to learn of Governor Bright-Starr's home's location in the first place. Let's discuss the facts of this case. At its core, it is a simple he said, she said that provides plenty of reason for doubt. The governor of our state, who has credible threats to her life and had her property vandalized earlier that same day, which has been confirmed by documented deposition and Zach Sanchez's testimony, respectively. She sees a car approach in the middle of the night and approach the same mailbox that was criminally vandalized earlier, which is a part of her property. Unsure of the threat she's facing, she pulls a gun and tries to find out who these people are and what they're doing. Once the governor identifies these men as Killian Clarkson and Doc Hilliard, she lowers the gun, as she stated to Ricky Lars and Mitch Weekings that night, who confirmed that statement in their depositions. With the gun lowered, a back and forth is had, and Doc and Killian eventually leave. Now let's discuss the charges and address the simplest matter first. Ella Bright-Starr faces an aggravated assault with a deadly weapon charge, which requires that the victim be an on-duty government official. The state has quite simply not proven that. They have submitted proof that Governor Bright-Starr was on duty as their Exhibit B, but they have not provided any evidence that either Killian or Doc were on duty at the time when they've had ample access and opportunity to submit any employee records for that date. As for false imprisonment and the crux of the assault with a deadly charge, it is quite clear that there was a justification to pull the firearm to begin with. Unidentified men approached the Bright-Starr property at night, unannounced, and approached a piece of property that was already vandalized beforehand. The governor pulls a gun to identify these people in the dark, and once Doc and Killian were identified, the governor lowers her firearm. At this point, the justification for restricting their movements ended, and therefore the governor acted as such, lowering the weapon. The force used by the governor is proportional to the threat of unknown people appearing to mess with her property for the second time that day, as it was vandalized hours prior. For the charge of uttering threats, Governor Bright-Starr called an officer of the law and trespassed the two men involved here. The Castle Doctrine of H.R. 112 allows for people to use force if there are intruders on their property. Any state that the claimed any statement that the state claims to be a threat is directly tied to the trespassing and the potential for the Castle Doctrine to be used if intruders are found at a later date. Quite simply, this case is full of contradicting statements and biases from the two witnesses it centers around. These contradictions and biases has created plenty of room for reasonable doubt in this case, leaving the courts with one possible ruling: not guilty. Thank you.
Thank you. All right. So, based on all that information, I'm going to go ahead and take some time to deliberate on this case. Quite frankly, there's a lot of information that I need to go through, and I would like to spend some time looking at this. Now, I'm not going to rush. I'm not going to waste everyone's time here, so I would like to call back court to order at past. That will allow about 22 minutes to go through all this information and review it all. Is that okay with everyone here?
Of course, Your Honor, take all the time you need.
Your Honor, unfortunately, I would have to step away. Vance is still remaining. Again, I believe I made it aware to the bailiff that I wouldn't be able to stay past a certain time.
Yes, I was made aware of that also. That's absolutely fine. Now both have rested and we've finished closing statements. It's just a case of deliberation, and then we'll read out the verdict afterwards.
Okay.
So thank you for your time this evening. I really appreciate that.
You're welcome, Your Honor.
All right. We'll call back to order at past. Thank you. You may all be seated, thank you. So I have deliberated this case at length, and I have reached a decision in the case 2024 CM222 State v. Ella Bright-Starr. I apologise, the hiccups have come back. It was alleged that on the 30th of June this year, 2024, Chief Justice Killian Clarkson and Justice Doc Hilliard entered the private property of Miss Bright-Starr, causing alarm and distress to the defendant, who is allegedly undergoing threats from other unknown people. The incident involves significant tension and misunderstanding, with the governor interpreting the judge's actions as a security threat and responding with a firearm, while the judges maintain that they were simply on a benign visit to drop off a welcome neighbourhood card. Although the property document... give me 1 minute. Although the property documents were clearly signed over a year ago, Justice Hilliard claims that in his deposition he believed Miss Bright-Starr to have just bought the house. I'm going to try and get through this. I apologise. Throughout first-hand witness statements and testimony, there is no denial that the defendant presented a firearm at both Clarkson and Hilliard. There is no denial that there was damage to a mailbox, and there is no denial that Clarkson and Hilliard were at the mailbox. The defence have maintained that the two arrived at the property without prior notice. But when does any person post a letter without prior notice? A postman or a mailman doesn't call ahead of time to let a homeowner know that they're going to be delivering the mail. Although this was in the middle of the night, there is nothing to say that this was a suitable time that worked for both Hilliard and Clarkson. In order to fully understand the allegations of trespassing and HR 122, the Self-Defense Act, and the Castle Doctrine, it is important to understand the location of the mailbox in relation to the property. Although the property lines have been submitted, there is no evidence showing exactly where that mailbox is in relation to the property at 2888 Hillcrest Avenue. The only information given is in a statement with Doc Hilliard and Detective Jackson, where Justice Hilliard states the mailbox is located on the roadway in front of the property to the left of the driveway. It's therefore reasonable to say that both Clarkson and Hilliard were outside of the property boundary and on public property. Therefore, Miss Bright-Starr withdrew her firearm and aimed it at two members of the public in a public place, who were both, at the time, government officials. Now we're going to break down the charges. Assault with a deadly weapon is defined as the threat of force against another individual or a group of individuals that involves the use of a deadly weapon without legal justification or excuse. A deadly weapon, defined as a tool that can easily and readily replicate death, must be present even though it is not actively applied or fired during the commission of a crime. The deadly weapon must be shown or displayed as a threat of force or otherwise used to force others into doing doing the suspect's will against the individual's own wishes. Miss Bright-Starr demonstrated a threat of force against two individuals by withdrawing her firearm, a deadly weapon, that can easily and readily cause death. The weapon was present and used during the commission of the crime. For this charge to be aggravated, an individual must be an on-duty law enforcement officer or a government official, the latter being the case of Chief Justice Clarkson and Associate Justice Hilliard. As such, this court finds the defendant guilty on one count of aggravated assault with a deadly weapon. Moving on to aggravated false imprisonment. This is defined as a restriction of another person's movement within any area without justification or lawful detainment. From the statements provided, both Chief Justice Clarkson and Justice Hilliard were held at gunpoint and told not to move. Both individuals were inside a vehicle and did actively attempt to leave. They were given an opportunity to do so, but returned to talk with Miss Bright-Starr. This would indicate that they are not fully restricted in their movement, but were held at gunpoint. This court therefore finds the defendant not guilty. Uttering threats is defined as knowingly uttering, conveying or causing a person to receive a threat of death or bodily harm and or destruction of personal property. In the first indictment submitted by Detective Sanchez, he states, Governor Bright-Starr proceeded to tell me that I needed to reach out to them and let them know that they are trespassed, and if they were to return, that she would have 2 dead judges on her property. Although this is a threat that meets the necessary criteria within the law for uttering threats, this was not conveyed directly to the witness. This was done via a third party and was stated to a detective. Throughout this trial, with the remaining evidence, there is no other evidence of uttering threats. As such, the defendant is found not guilty. I'm now going to move on to sentencing for 1 count of aggravated assault with a deadly weapon. Miss Bright-Starr is hereby sentenced to 30 months in Bolingbroke State Penitentiary and will pay a fine of $2,500. Sheriff Stevens, you may place the defendant in handcuffs.
Ms. Bright-Starr, can you walk over here?
This court session is now concluded. Thank you everyone for your time this evening. Go forth, be safe, and have a wonderful evening. Thank you.
Thank you, Your Honor.
You got Zance. Alfie, can I get you like for 30 seconds?
Do you say you need me?
Sure.
I just got one
Come through.
question.
Come
One
through.
question, so.